Good morning, everyone. Thank you for coming to the Nursing Grand Rounds this morning. How are you, Taylor? Today, the Nursing Grand Rounds is on legal documentation, and the name of it is Documentation Loopholes Don't Get Caught in One. We do have two of our hospital attorneys, Kelly McFadden and
Jeremy Willett.
They're two of our hospital attorneys, and they're going to help us with this because they're going to actually do a little bit of a mock trial to show you what it's like to be in the courtroom. So at first, Kathy McCauley and Dana Gore are going to do some presentation for you. Then we'll go into the next segment, and then we'll have time for questions and answers. Okay? So I'll let you take it away. Oh, and please make sure at the end that you fill out your evaluation and hand it in so you can get your CEU certificate.
Good morning. I'm Dana Gore. I'm the risk manager at Northlake campus. Kathy's our risk manager here at the Southlake campus. Today we're going to talk about documentation. And it only gets legal if you don't do it right. So we're going to focus on actually documentation. Okay? So, these are our learning objectives, is to increase the importance of accurate, complete nursing documentation. You're going to increase your knowledge of legal implications in inaccurate documentation, increase your understanding of following hospital policy, and increase understanding of court mock. We're going to do a little mock trial for you just to see if you're ever in this situation and you have to be on the witness stand.
Dana, they can't hear you.
They can't? Oh, okay. That's why I have the mics.
Yeah. He's used the mic, we can't hear you. And we are taping this. We hope to post this in case you want.
So, documentation is not an easy task for nurses to do because sometimes you're so busy taking care of the patient and clicking through Epic and trying to make sure you got all your T's crossed and your I's dotted that you just do the flow sheet documentation. Sometimes you have to do a little bit more narrative in that documentation. And it's required by legislation, our regulatory bodies, and it's part of your job description, actually, to document accurately. And from a legal perspective, the health record is considered the most detailed and reliable source of evidence once the adequacy of care provided to a patient, if that record ever undergoes any scrutiny. That's your lifeline. That's documentation. That's what you actually did. So if it's not documented, what you learn in school. If it's not documented, it's not done. So whenever I say, if it's not documented, you say, it's not done. Okay? Okay, and this is some of the reasons why nursing documentation is so important. You are a credible source. If you don't document appropriately, then we can't see a clear picture of what's going on with that patient. So, if you don't document, then it's determined that you didn't practice within the standards of care of your job. So I'm trying to put this point across very clearly. You have to show a picture of that patient from the time that he enters our facility until the time that he leaves. We need to see a story. It's just like telling a story. And when there's gaps in that story, then it makes us liable and almost makes us seem negligent. And it's totally hard to defend if you don't document appropriately. And in order to challenge the validity of the record, we use the ANA Principles for Nursing Documentation. There's a website there. Go online and just review that. Because, I mean, we get so caught up in our day-to-day activities of being a nurse, we sometimes overlook and take shortcuts, and we don't practice within a standard of care. And these are some potential legal claims. If we should have a potential legal claim, and this is a question I'm going to ask you. Should a legal claim arise, would a complete copy of the medical record and all other related records be disclosed as evidence? Yes. Yes? The answer is yes. A complete copy is summoned by the prosecutor or plaintiff's attorney. Even x-rays, paging records, shift reports, email, faxes, all that could be included with this disclosure of any records that we may have. And the plaintiff's counsel will look for lapses, errors, amendments, deletions, inconsistencies, late entries, vague entries, like patient failed, and that's it. You don't even put it in the EMR. You do a risk control report, and it just says patient failed. It's not in the EMR, so if it's not documented, it was. So the family can say, I found my mother on the floor. She broke her hip. But there's no documentation in the record about it. So it's like we're hiding something. It makes it hard to defend. So the defense counsel will look for evidence to substantiate the healthcare record. They often share the records with clinical experts who are asked to commit on whether the care provided by the nursing staff met the requisite standard of care. So most time, if it's a specialty, so to speak, they'll reach out to maybe a cardiologist, a medical expert, and that medical expert and a couple of others will gather a panel, and they will look at the record and see if we met the standard of care. And if we did, that's to our favor. But if they say we didn't, that's not to our favor. Well, here's another question. Is it the hospital's responsibility to protect nurses in any legal claims?
No.
No? That's the consensus? Okay. The answer is no. Legal claims continue to demonstrate the most complete, competent, caring, and dedicated nurses may be defensive in the absence of good documentation. Poor documentations can be a negative impact on the health practitioner's credibility. You are credible, and I tell you, this protects you, because if the records go to court or they have to be reviewed and it's determined that there's lots of gaps in that record, that makes you not credible. And that plaintiff's attorney will eat you alive. And then if the jury thinks you're lying, then that's just it. It's like, okay, let's go settle this claim. So it is very important to document. And Kathy's going to talk about the American Nurses Association positions on documentation, and then we'll go into our mock trial.
Good morning. Okay, as you can see, where do these standards of care come from? We set them. Nurses set them. A doctor doesn't set them for us. A hospital doesn't set them for us. We, through our American Nurses Association, which is involved with our state nursing organization for licensing, we set the standards. That's why the standards may be different from state to state. And that's because we as nurses know what is the best care that we as nurses can go ahead and give within our profession. So the standard of care, as according to the American Nurses Association, is that nurses must document a thorough evidence-based knowledge of the impact of the care that they provide on the outcomes of the patient's experience and the data, the nursing sensitive measures that are collected. Basically, we follow the standard of care, we document that standard of care. Those charts are reviewed not only by insurance companies, so that payment will go towards the patient, not only by attorneys because there was a lawsuit, but they'll also go ahead and be reviewed by our Indiana State Association. And they'll see how well we're following those standards of care. They'll collect that data. We're submitting data right now to the national database here in Indiana, and there's soon to be other databases that we're going to have to submit our information on, and this is all based on our documentation. Related to this documentation, the data that we collect, is how we move forward so that we can give better care in the future. The better your documentation is, the better we can see the patient's needs, how you met those needs, and if there's cracks in the floor of how we deliver our care, so that we can go ahead and start a process for improvement so that we can better protect the patient, give better care, and as nurses, we can go ahead and feel more, I don't want to say just fulfilled, but because it is fulfilling, but we also then can go ahead and promote more protection for the nurses as we gain more skills and more education. Does this all make sense to you? We are the ones that set this, so why would we not follow our standards? And the only way our standards are met is it reflected in our documentation. Dana brought up a very important point. If it's not documented, it's not done. How does that affect us? If a patient should fall, ended up with a fractured hip, the physician and then the care that's given to that patient later on is going to show that he had a fractured hip. If it's not documented, like she said, then it looks like we're hiding something, that we did not do what was necessary for that patient to prevent that fall. Without that documentation, it shows us a failure to monitor that patient, and it shows a failure to rescue that patient. These are serious, serious negligent charges for a nurse. So, if you document, if an issue occurs, if an event occurs, go ahead and document that so that you are better protected. Does this make sense? It's kind of scary, especially whenever you're auditing the charts and you know the person who is actually giving that care, and that care that she gives or he gives is so excellent, and that person is so knowledgeable, but yet it's not reflected in their documentation, and it tears out your heart. What I'm going to do now is showing how our charts, our documentation actually illustrates what we're going to do as a mock trial. Poor Dana. That will illustrate what had happened to, based on the documentation. And this is actually a case that occurred. So the questions that you're going to hear are actual questions that were asked. The answers that you're going to hear are actual answers that came out. Now the setting is in an emergency room setting, and the documentation reflects that which was either documented or not documented in the emergency room. This has, even though it's a real case, it has nothing to do with our emergency room, so I don't want you guys to think, oh my God, was I working ED that day? And is this my case that I was involved in? No, it's not, okay? So what I'm going to do is go ahead and introduce Kelly McFadden, and who is with O'Neill McFadden and Willett, and I'm going to introduce Jeremy Willett, who is also with the same firm. These are our hospital medical malpractice and general liability attorneys. Kelly, as a matter of fact, was a nurse for many, many years before she went on into law, hoping to be able to protect us as we go through our different lawsuits that are either that have been submitted against the hospital and the hospital staff. So, you guys, Dana will be our nurse,
victim would you approach?
And I'll hand it over to them.
Good morning, everyone. Thank you for coming. I'll just give you a little bit more background on the case so you can understand some of the questions and why they were asked. This is a deposition, like Kathy said. I was defending one of the physicians, the radiologist in this case, and we were in the deposition at the hospital downstate, and the plaintiff's counsel that was asking the questions was actually also a former nurse that had become an attorney and knew just exactly what to ask. The patient had come into the emergency room on the 18th of the month complaining of constipation, some stomach pain. He had gotten an enema at home from his sister-in-law, who was a nurse, prior to coming into the emergency room. They discharged him home after he, refused any additional care. You'll see it wasn't documented, his refusal. Came back about 18 hours later with a perforated bowel. And ended up being rushed to a higher level hospital where he underwent a procedure, ended up with multiple infections, multiple other surgeries after the fact. As I was sitting in this deposition thinking about this poor nurse sitting there and her attorney, who fortunately was not me, I said, I'm going to use this someday to teach my nurses that I represent what not to do. So hopefully if you've ever been in a session with Jeremy or I, or ever been through a deposition, you'll see that you were better prepared how to answer some of these questions. But this will just show you where, the lack of documentation can really get you into trouble, even as a fantastic nurse. So I'm going to be the plaintiff's attorney, and we'll get started. So it's kind of scattered. You don't have a lot of background in the questions. That's why I wanted to give you some background.
I'm going to be her defense attorney, but I think you're going to see that I can't do anything for her.
Okay, ready, Dana? Yes. Okay, she would have been sworn in front of the judge. There's a jury here. Ms. Gore, as an ER nurse, do you do a nursing assessment when a patient comes into the emergency room?
Yes.
And you see that as part of your job?
Yes.
What does a nursing assessment include for an emergency room patient?
It depends on what the patient is there for.
All right. What helps you decide what you're supposed to do for a particular patient?
The patient complaint.
Let's look at your triage note for Mr. X. What did you record as chief complaint?
Complaints of abdominal pain, fever, body aches that started 2 days ago.
Okay, what started 2 days ago? Was it all of the things you've just described, or is it just one of them? I'm trying to discern. Was it the fever, or the pain, or both?
I don't know.
You don't know how long he'd had a fever other than 2 days ago?
I don't remember.
How high of a fever had he had at home? Do you know that?
No, I don't remember.
What else did you note in the box, or chief complaint?
Nausea, vomiting, last BM, and that he had a headache.
Do you know how many days it had been since his last bowel movement?
I don't remember.
Looking at page 608, ma'am, we're talking about the chief complaint still. Do you know how often Mr. X had had a fever?
I don't remember.
Was his fever consistent or intermittent? Did anything relieve it?
I don't remember.
Okay, well, let's look at the other side of the page. It says initial assessment done at 11:49. What would be included in the initial assessment?
Well, the general assessment and the physical assessment.
So it is your representation sitting here today that you actually did a physical assessment of Mr. X?
I don't remember, but I don't think it was documented.
Do you believe that to be an important part of your job?
Object the form.
Ma'am, is it your role as a nurse to document that you did a physical assessment of a patient?
Yes.
And in fact, he's there with abdominal pain, correct?
Correct.
And there is nothing here noted about any examination of his abdomen, is there?
Objection, she's already testified that she doesn't remember.
Ma'am, you can answer the question.
No.
And you would have been the one as the nurse to do that, right?
Yes, the nurse, yes.
Is there any reason why you did not do a physical assessment of Mr. X's abdomen when he presented with abdominal pain? Ma'am, please answer the question. Ma'am? Ma'am, please answer.
It's
the
not
question.
documented. I only saw the chart 2 weeks ago. And it's very unusual for me not to do a physical assessment. I usually do a physical assessment. I know I do because I consider myself a nurse who is a patient advocate. And I treat my patients as though they were my own family.
Okay, I appreciate that, ma'am. And in fact, you see the physical assessment, the nursing physical assessment, as an important part of your job, don't you?
Yes.
So if you take the steps to do the important part of your job, wouldn't it be also important to document and write down your findings?
Objective form.
Yes.
And we don't have any abdominal exam that you did of this gentleman at any time, do we?
Ask and answer.
Ma'am, did you document an abdominal assessment of this gentleman?
No, it's not documented.
Okay, let's move on. Up under general appearance, it's marked mild, moderate, or severe distress. Which did he have?
Well, by looking at my charting, I'd say mild.
Why do you say that?
Because I'm sorry.
That's okay, go ahead. Why did you say that it was mild?
Well, correction. I checked it, and it was moderate or severe. I would circle it.
Okay, look over here, ma'am. Beads of sweat on his forehead. Is that your writing?
Yes.
And what was significant to you in your observation of Mr. X at that time regarding beads of sweat on his forehead?
Well, it's an observation I made.
All right, let's look at page 609. There's a box there for vital signs. Do you see it?
Yes.
Does that mean that as far as vital signs, there's nothing other than his triage vital signs that have been documented at any time during his emergency room stay?
Correct.
And there were no discharge vitals done, correct?
Correct.
Did you at any time consider going back and noting why there weren't any vital signs done while he was a patient there, or why any discharge vitals were not done?
No.
Did the emergency department or the hospital have any policies or procedures or description as to how a soap suds enema was supposed to be given to a patient at that time?
Yes.
Did the emergency room, and what did it say?
I didn't read the policy.
Have you ever read that policy?
I don't remember. I mean, there's lots of policies and procedures.
Do you see it as part of your responsibility as an emergency room nurse licensed in the state of Indiana to be current on the policies and procedures of your facility?
Yes.
Do you believe it's part of your nursing responsibility to understand the adverse effects that can occur with treatment that you provide?
Yes.
And did you do any discharge assessment of Mr. X?
By assessment, you mean?
Anything. Did you do anything before discharge?
No physical?
Now, after you've given him 3 enemas in the emergency room and you had the results that you charted, did you do a physical? Did you examine his abdomen to see what it looked like after you delivered 3 enemas?
Objective form.
No.
Were you involved with the discharge instructions for Mr. X?
Yes.
And are there discharge instructions you would have given Mr. X?
Yeah, I would give him this discharge sheet.
Okay, I understand that. Were you involved with any of the discharge information given to Mr. X?
I would have read them to him.
Do you know whether the physician went over any of this with him?
I wasn't in the room at the time.
So do you have to sign off anywhere on the discharge instructions that you've gone over them with Mr. X?
Yes.
Where do you do that?
Well, after the patient or responsible person's signature or instructed by.
Who signed in that instructed by area?
It's not signed.
Any reason why that you know of it was not signed?
Probably was busy. No.
Well, it was supposed to be your signature, right?
Yes.
Okay, let's move on. You made a nursing diagnosis for Mr. X of abdominal pain, correct?
Yeah, that was his chief complaint. alteration in comfort complaint. Well, yes, I did.
Okay. Did you make any efforts, ma'am, as a nurse, to discern what was causing the abdominal pain?
Well, there's a lot of things that can cause abdominal pain. I don't make diagnoses.
Did you make any effort to discern what was causing Mr. X's abdominal pain?
Check the form. She started testifying. She doesn't provide diagnosis.
Okay, ma'am, let's look at the top of page 609. The top column on the right says nursing diagnosis. Do you see that?
Yes.
And your nursing diagnosis was complaint of abdominal pain, correct? Okay. The entire thing is checkmarked. Alteration in comfort is evidenced by complaint of abdominal pain. That was your nursing diagnosis for Mr. X, correct?
Nursing diagnosis, yes.
Okay. Did you make any efforts, ma'am, to discern what was causing what you determined to be the nursing diagnosis for Mr. X?
Well, to make a nursing diagnosis, I looked for the patient's chief complaint. I could also put fever because that's the discomfort the patient was having.
Yes, ma'am.
But I don't make the diagnosis to what's causing abdominal pain, though.
Nor did you make a determination as to what was causing his fever, did you?
No, that's...
Well, his temperature was only taken once while he was there for over 5 hours, correct?
I was busy with other patients. We had a trauma, I guess, yes.
Okay. So we don't know if he had a fever at any other time other than triage, correct? Because you never took his temperature.
Correct.
Okay. Now, I was a nurse, and my experience as a nurse giving an enema, there are times when patients cannot keep the fluid in when you give them a large volume of fluid. Are you familiar with that?
Yes.
Was Mr. X able to keep the fluid in until he went to the bathroom to release it?
Yes, but I don't remember.
Okay, and did you chart anything about his inability to retain the fluid, ma'am?
No.
Okay. In this case, after the events that occurred in the emergency room and he was discharged and came back, the nurse was called back to the nursing manager's office because she had forgotten to document that the patient had received another enema at home before coming to the emergency room. So this now transitions into her addendum documentation that she made 4 days after the fact. Ma'am, how were you unaware that nothing was in the chart about the enema that Mr. X received at home? Is it because your nurse manager told you that she needed to chart it?
I'm not sure.
Okay, but you were called into the hospital on your day off to write an addendum in the chart about an enema being given at home, correct?
Yes.
So where did you have to go to create the addendum? What did you have to do to add this addendum note into the chart?
Well, our T-sheet drawer, where we keep the T-sheets. These are the T-sheets.
Okay. What's a T-sheet? What does the T stand for?
I believe it's, I'm not sure, but I believe it's who created. I don't know.
Okay. So you go to the drawer and pull an empty T-sheet when you came in on the 22nd for your day off, correct?
Yes.
Well, and then what happens once you've pulled the sheet out?
I document it.
And then what happens after you write this new part? What did you do with it?
I don't remember.
Okay, were you in the nurse manager's office when you filled this out?
I was in the office, I believe. I don't. Well, would be alone in the doctor's lounge next to Tammy's office.
Okay, was Mr. X's addressograph stamp up here or a label up here at the top of the page already on the piece of paper when you filled it out?
I don't recall.
Well, is the stamp created by an adhesive label or some type of punch device?
No, it's a adhesive label that our hubs put on our sheets.
Okay, so my question is, when you came into the hospital 4 days later, was there already an adhesive label on the blank T-sheet when you added your addendum, or was it a blank sheet of paper with no adhesive label?
Well, probably it was blank because I got it out of the drawer. I opened it and got it out of the file cabinet where it's located in the nurse's station.
So you filled it out, and did you take it to Tammy, or what did you do with it then?
I believe so, yes.
Were you told at any time why this piece of information that you added as an addendum was important to go back and add?
No.
Were you told what to add?
No.
So was there anything else that happened in Mr. X's care that should have been added, an addendum that we don't know about from your charting?
Well, going back, I probably would have added that he was adamant about getting out. And I offered a wheelchair for him, but he wanted to walk.
Okay, so why didn't you add that 4 days later when you wrote this addendum?
I don't know.
Okay.
All right. So, you see me? By the time that these cases come in, most of the time the plaintiff's attorney has had about 2 years to sit and review these records, to just review them and review them and review them and make questions. By the time we're walking into this deposition, there is very, very, very little that she can do or I can do for her. Our hands are tied because of the documentation. There's no way that she can say, oh, I remember that. The plaintiff's attorney loves it when a nurse says that. Oh, really? Tell me what this patient looks like. Tell me this, tell me this. You see so many patients, there's no way you're gonna remember a particular patient unless something really unusual happens. She's backed into a corner, she has no documentation to help her out, and there's nothing I can do. I can't tell her what to say. Documentation is very important. Like I said, these plaintiff's attorneys are very talented. They spend a lot of time, and by the time we walk into a deposition with these kind of facts, we're in trouble. Now, I know no one in this room would document like that, all right? So, much different circumstances typically when we get involved in the Methodist cases. I have stuff to work with, I have defenses that we can develop, I have great people to work with, so we have that going for us. But this is just an example, a very exaggerated example of how bad it can be and really puts us behind the 8 ball. How did that feel, Dana? Did that feel very uncomfortable? And I know none of you would like to be in that situation. So again, the takeaway from this is document, what I say is document your mindset. Because if I can look to the records and I can say, oh yeah, I can explain what she's doing, look, or he's doing, I can walk right through the records and show the mindset of why you're doing what you're doing, that's huge. Because ultimately, I think in front of a jury. I'm in front of 8 people, and I have to tell a story to them. And if I can tell the story through the records, it's going to be easy to defend you. It's going to be easy to tell your story, and you're going to look very credible. If we're relying upon memories and things that are not documented, it gets dicey. Because think about it. You're going to have a patient with some sympathetic story, and it usually is very sympathetic, and then we're going to have the professionals, and you saw your own nursing association standards, that's going to be blown up. Right there is Exhibit 1. And this was the job that the nurse had to do, but where's it at? It's not in the records. Again, very difficult for us to do anything at that point. I've heard that sometimes people say, you know what, it's okay, the attorneys will get us out of this. There's only so much that we can do. I cannot ask her to lie. I can't ever instruct her to lie. We got to tell the truth, and then if our hands are tied, we're looking towards settlement. And that's not what, obviously, I like to do. That's not what I want to do for your behalf or the hospital's behalf, but that's where we would end up in a situation like this. One last thing from me. I've always heard that the nurses are the eyes and the ears. And I get it, the physicians are involved also, but the nurses are the ones that are there constantly. And if it's not coming from your documentation, it's probably not going to be in the physician's documentation. And again, I need to rely upon, that's one of the first places I go, nurses' documentation to tell the story. It's so critical. I look there, I see the story, and then I fill it in with the physician perspective in their records. If I can get it from those 2 sources, I feel really good about the case, because no one's here to hurt the patient. No one's here. You're here. You have good hearts. You're trying. This is why you went into this business. But again, the plaintiff's attorneys don't care about your good intentions. They don't care about any of that. All they see is this person's injured, they're going to go all the way and make it as uncomfortable as possible for whoever's sitting in that chair.
The one thing about good documentation is you probably won't even get asked to meet with us or the plaintiff's attorney, because if your story's in the chart, we know it. We don't need to meet with you. I just tried a case back in September. The patient had been in the hospital down in Indianapolis for over a month and had a bypass of his leg with a very, very sick man. And the question was whether the leg was infected. And we didn't need to call one nurse from the hospital. This was before electronic documentation, when every day the nurse was writing every time she went in the room and observing the leg. And we were able to paint a picture of what that leg looked like every day without having the nurse having to come in. The case was from 2002 or earlier than that. So it's also, 15 years after the fact. So not one nurse is going to remember this patient, his family, his leg, any of the circumstances. But the documentation was excellent. So not one nurse over the 10 years, 15 years of litigation, we didn't have to talk to one nurse at all because the documentation was so great. Some of the things that we see that are make it a little bit harder, like Jeremy said, the nurses are there with the patient for 8, 12 hours. And just clicking the notes that you have to fill out at certain points, your drop-down menus, don't tell us a lot. A lot of them are, just automatically clicked and filled, copy and pasting. They can get all of that because they ask for the audit trails now of your records. So it shows that when you clicked open a box that it was open for 0.04 seconds. And you made the click and closed it and went to another one. Documenting also is difficult when you write in your note and it shows the time that you wrote the note, but it's applying to something that you did earlier in the shift. So when you have a note that's written at 8 o'clock and the patient was, something was going on the patient, but it was maybe from 5 o'clock, it's very difficult for us to time that back. So when you're writing a note after the fact, put down the time that the event happened. Like Jeremy said, the doctor's only there once a day, if that. So we have their one note that a lot of times they write later, after they've seen the patient. So any help that you can, or information you can provide in the record, like at 1 o'clock, Dr. So-and-so was here to see the patient. Orders, updated him on status. Give a little blurb about what status you gave them. Orders received. We can go back and look at the orders that you entered and with his name and the time that corresponds with that time. But it doesn't have to be a ton of information, but just to guide the thought process of what is going on helps tremendously. And again, if a case is well documented, a lot of the times they're not even going to bring it to suit because they can't find anything in the record. When they see glaring holes in the record, it's, aha, something must have happened and they didn't want to write it down. Also in this case, you saw patient refusal of care. He wanted to leave. He refused to get his vital signs taken. He didn't want to stay. They had done an x-ray. He refused to stay for a CAT scan because it was going to take another 2 to 4 hours. This is a small little hospital, rural hospital. And he didn't want to do it. They didn't document any of that refusal. So if a patient, doesn't want a monitor on, or doesn't, want a certain medication, or doesn't want some kind of treatment, or doesn't want to turn, that's a big one because we see a lot of bed sore cases. Write that refusal down. It doesn't have to be a paragraph. It just, went to turn patient refused. It would help if you, would put in there, advise of the risks of bed sore or something of that nature, just so that you have fully informed them that, because, you do it, it's time to turn. Nope, I don't want to turn. Okay, well, we're doing this to prevent a bed sore, and they still refuse. Just document, that covers you. And we see a lot of bed sore cases. And those are probably the most intensive in terms of documentation because there's so much on you guys to document, so frequently. And if one of those are missed, it's, it becomes problematic because, oh, they didn't turn them. And it's like, well, no, they were taking care of 8 other patients and missed that one documentation note. But, their favorite line is, wouldn't you agree you learned in school if it's not documented, it wasn't done. And that gets thrown back a lot. So
So I hate to say that I feel like I'm here to scare you, but I feel like my job here is to scare you guys. And I'm really not trying to do that, but I'm sure we could stand here and give war stories all day and tell you about things where I was hitting my head on the wall saying, why did they just say that? We never really know exactly where the plaintiff's attorney is going to go. They don't show their hand, obviously. I'd like to hear from you guys. What questions do you have? When we were at Northlake, they had a bunch of questions really put us on the spot. So I'd like to see what you guys come up with, or do you have any just questions about recommendations on how to handle things? Kelly was touching on, substance there. Has anything crossed your mind while we've been talking so far that makes you go, hey, wait a second, how would I handle this? Or how does insurance get involved? Or how do these attorneys get involved? What's the process? I'm not going to make anybody raise their hand. I mean, I don't know if anybody, I don't recognize, I'll just say I don't recognize any faces. So I don't know any of you. So the process, again, it's a year to 2 years before we even get the case in our door. So, you might not, you probably have no idea that the family is even working litigation through the channels, and then all of a sudden you're going to get identified as a potential witness, and then get a phone call from either Dana or Kathy because we're saying, hey, we want to talk to you. Again, if that happens, I don't take this as a slight, but usually when I'm done with the case, I get the same thing from nurse, doctor. I'm so glad I'm never going to have to talk to you again, Jeremy. And that's a compliment, actually. I really take that as that. But that's the scenario we're in, is I'm actually on your side. I know it might not feel that way when I'm taking you through a prep session. I'll tell you about that. So if you're getting deposed, that's what we would call this right here in a deposition. That's not typically done in court. That's typically done at one of the lawyer's offices. And I don't just walk you in, put you down on the chair and say, good luck. All right? That's not what happens. You get to sit with us at our office probably for 1 to 2 sessions of 4 to 5 hours each, and get to essentially walk you through the questions that we think she's going to ask and make you feel very uncomfortable. And my goal in that regard is to make you feel more uncomfortable than you do in the actual deposition. To teach you about the pitfalls of what not to say, because there are things that are in every deposition, and if you fall into the trap, I can't get you out of the trap. Right? We don't need to get into that for purposes of today, but those exist. But we would walk you through every one of those circumstances. We'd say, hey, here are the main issues, here's the documentation. I'm not a nurse, Kelly is, so I would definitely rely upon your expertise in saying, hey, what about this? Hey, my charting says this. We talk it through. We talk through the whole process together. Then we go to the deposition probably about a week later. Trial is a totally different animal. If it ever goes to trial, you're back in my office again for 2 to 3 sessions. Now we're going to be in front of a jury. Now, why I bring that up is because, remember that deposition thing I was just talking about? Every single word you say is written down. Every single word. And I promise you, any good attorney is going to sit there for hours and dissect every single word that you've said, and anything he can take out of context, anything that is good for him, he's going to have blown up about that size on the wall at the trial. And the second that you squirm a little bit at trial, he's going to throw it up on the wall and say, oh, you remember when you said this in your deposition and you were under oath and you were telling me you were telling the truth? It doesn't look good in front of a jury. So it all comes back to scaring you, to the importance of documentation. Document well. I get it. It's really easy for me to say that. I'm not a nurse. I get the benefit of hindsight. You don't know which patient's going to end up suing. I get that. All I can say is do your best to document the mindset, get it in the record, because when that happens, we're much better prepared for the deposition site, and then at trial, you're covered, and I can protect you.
So anybody, I know you guys have questions. Has anybody here been to court? Has anybody here been deposed ever?
I'm seeing
Anybody?
about 3 or 4 hands, yeah.
tell, how did you feel?
Horrible. Well, I was a director, so I was a manager. It was something someone else did. And I felt like he just picked it apart. Like,
it was a care plan, and like, you know, we could basically just add to. We had new systems, and not all the nurses knew how to work it. So she hand wrote it in, and then when we had the meeting in the morning, the nurse manager of that unit went ahead and she typed it in. But this attorney, I felt like wanted me to. He was like thinking we were falsifying the records when we wrote it in, and I felt like he was making me feel like a liar the whole time. And it was like 2 hours
Shocking.
of 2 hours of the same question over and over again in 20 different ways. It was actually kind of annoying.
And you were not even the person that wrote.
No,
Yeah,
I was just in
it doesn't
management,
matter.
so I got drug
Yeah.
into it.
It doesn't matter if you're even tangentially related. If your name shows up in a chart, that's all it takes. All right. So again, I know I saw some other hands come up, but the point is well taken that it doesn't have to be even you. You could be asked to testify, and then they're going to try to use you against your own colleague.
I really want to emphasize that if you're doing something outside of standard, you're doing it early, there's a reason you did it early. Document that reason. And if one of our drop downs doesn't work, put another there. Make a comment so it's very clear as you're sharing what happened with the patient. So that's one instance. So anytime you have a change or you're doing something, give us a reason why you did it, especially if it's abnormal. Or a Foley that's being changed every 3 or 4 days, there's a reason for it, but then when I look through the chart, I can't find anything. When I sit with you all and we talk about it, oh, the patient was leaking, and this is what we did and why we did it. The other thing in copy and pasting, I will look at documentation on an IV site, and we changed the dressing at 8 o'clock, we changed it at 10 o'clock, we changed it at 12 o'clock. It's the copy and pasting again. When you copy and paste, remember to change what you didn't do. So if you didn't flush it, it's infusing, that's fine, take those pieces out. But again, you're showing a picture of the patient, and I will pull it apart and ask you why you're doing it. But again, try to show what you're doing.
One thing on code records. Code records are mentioned. I've had a few cases where I get the code record, and I've been in codes, I've been the documenter in codes, and it is pristine. There is not a stray mark. It is beautiful handwriting. And then when I go and I talk to the nurse, well, we rewrote it because it was sloppy. Do not rewrite your code record, because no one expects a pristine, beautiful code record. And if you then say, well, we rewrote it so you could read it, well, what did you leave out? What did you add in? Do not rewrite the code record. You have a policy for, if you need to alter documentation, use that policy, because you will be pulled apart for any type of rewriting of a document. And there's really nothing. It's called spoliation of evidence. It's a huge issue, and cases settle because of it. And when you think you were doing the right thing to help and make sure the record's clear, it loses the case. Another thing, it sounds odd because it really has nothing to do with the care you provide, but a lot of cases we see where the family is actually present and in the room when a fall happens, or they're getting the patient up on their own. It really helps us when you document when the family's in the room. So just a little note, family present. Because we've had many cases where the family has undone restraints, they have, like I said, gotten the patient up when they shouldn't be getting up, things of that nature, and it usually ends up that we're in that position because something bad happened, but there was no documentation that the family had been present at the bedside all day, or that the family is, bringing in herbal supplements and giving them to the patient, or, doing things like that. Make sure you're documenting anything regarding the family and things that they're doing with the patient that they should not be doing.
I have a question. When it comes to policies, should they be really tight and stringent and list and very detailed, or should they be more vague, or kind of just give the general lay of the land? Which is going to be a safer policy for our nurses?
You know, it depends what the issue is. You know, documentation, you have to document certain things. But it's a little, you're not held in as tightly if the policy's not as tight.
Wiggle room.
Yeah, you want wiggle room.
But so it's usually the most stringent is what you're held to, correct? So if your policy says such every 4 hours, but the standard evidence-based guidelines say you should be doing it every 2 hours, would you not be held at the 2 hours? Or would you be held at the 4 hours?
You'd be held at the most stringent. I mean, they're going to pull your policy. They ask us for policies and procedures now because most of them are electronic. We'll print out the table of contents and give them to them. They ask for your personnel records to see if you've been in services, if you've signed off on reading those policies. You know, we try to keep as much out as we can, but there are certain things that, you know, you have to give them.
Question, so when it comes to cars and things like that, so in the standard electronic charting, we just click the boxes. So when you do a Foley change or PIP line dressing change, is it better to include the steps in your documentation or just click, click, click?
If you do the same thing every time, you don't need to put the step every time. If there's something unusual, definitely put that in. Because what's going to happen is, on certain things like the changing of a Foley catheter, you're going to, you know, be asked a question about, well, you know, how do you go through the process of doing a Foley catheter? How did you do it in this patient? Well, I don't know how I did it in this patient, but I use the same procedure every single time, and this is what I do. And that is credible testimony, your custom and habit and your practice.
And our policies are laws. Just like, you know, the state has laws, our policies are our laws. So they'll go back and they'll grab a policy. They ask for policies all the time. And if our policy says you're to do ABC, they expect for ABC to be done. So just think of our policies as the law.
So as attorneys, I mean, I guess I struggle with this all the time because there are, what, 500 of them? So how would we know 500 policies, you know? And it just kind of, I always struggle with, they go, what's in a policy? Okay, but that's very difficult for the nurses in this room to know all those policies and to be held accountable for knowing all of that. I don't.
You mean you don't take them home and read them every night?
No, it's not every night. Right.
Yeah, no, you're not going to know all the policies. If a question comes up, and that's why you do want to keep them, you know, with that wiggle room. And there's, you know, if there's an exception and you feel like this probably was not done according to policy, then write, you know, why. Now, I didn't follow policy because of this, but, you know, here's the situation. These cases are based about, are what's reasonable under the circumstances. And I always tell my clients, it's the circumstances that we look at that make or break the case. So if there's something unusual that happens that's outside of the norm, or there's some circumstance that occurs, document that, because that is what we will use to defend the case. In terms of the policies, I mean, I don't know what you have in terms of training and how often they have to review the policies. I mean, you know, when we get the policies, I was just asked by a younger attorney, can I give these policies? There's a, you know, a policy on sentinel events. I'm like, well, it's in the book. Yeah, we've got to give it. Did we follow it? It wasn't here, and it was like, well, no. And I'm like, well, I mean, they're still entitled to the policies. We just have to be ready when they ask the question, why didn't you follow the policy? You know, why you didn't do it. So, you know, if it's something that it's abnormal, I mean, you have access to the policies right on the unit. You know, if it's something abnormal, just, you know, pull it up, or, but yeah, you're not gonna know every policy inside and out.
I have one more comment off of Kathy's. I do concurrent chart review every day, and I'm frequently calling nurses to say, you charted this, because they copied and pasted somebody else's comment. I was like, oh, I didn't chart that. Well, if you copied it and it's a comment signed by your name, you charted it, whether you know you charted it or not. So always look for those comment boxes. If they're there, somebody's handed or somebody has ad-libbed something in there.
Or I like the comment boxes that just say other, and there's no reason inside of it, so it's like, okay, what did you want to tell us that you forgot?
Yes, on med administration, I see that frequently. It will say other, and it says give a comment. and there's no comment. So there's no reason you didn't give that med other than other. And just one other thing, nurses cannot hold medications because they think they should, like the Lovenoxes and this. You need a doctor's order to hold medications, or a parameter when that order was written. But we can't just randomly make decisions if we think we should hold it or not.
And that ties in with what Kelly said. When we go to do something, document the reason why. I'm holding this, Lovenox is due at 9 a.m. I'm holding this Lovenox to clarify with the physician if he wants Lovenox and the heparin given at the same time. Okay? Does not look like then that you're making a medical decision. You're doing what a nurse would do according to standard of care. You did an assessment, you formed an opinion, and now you're going to clarify it with the physician. It's the circumstances, like Callie said, that will go ahead and defend you, but it won't defend you if you don't document. I changed that Foley. Foley catheter change per policy and procedure. Why did you change that policy and procedure? You put in the progress notes, RE, leaking around the Foley. RE, patient complaining of pain at the insertion site. 2 or 3 words, that's all you need.
I touched on it a little bit as well earlier. When you call a physician, and we've gotten in trouble in some cases where the nurse calls the physician and writes, call physician, updated on patient status. The physician, in this one scenario, the patient ended up bleeding out before the physician came in because the nurse had called about a higher level of pain. That's what the physician recalled, and the nurse didn't tell the physician about the blood pressure according to the physician, and it wasn't documented. And the blood pressure was dropping, and so the physician, it's the middle of the night, says, okay, give her another pain pill. And, you know, her blood pressure is bottoming out, and there's no documentation that the nurse told the physician about the blood pressure. I mean, I have a hard time believing that she didn't, but it wasn't documented. So just a little blurb on what you're contacting the physician about, you know, unstable vital, change in vital signs, or things of that nature, so that it covers you. You had a question in the back in the white coat.
I had to go to court once, and it was the worst experience of my life. And the patient came in at 3 o'clock on Friday. I never saw the patient. I was the manager of the unit, and she was discharged by the time I went home. What the hospital got hung on is we didn't follow our chain of command, and I don't think a lot of people realize. The doctor was in the room with the patient, but the nurse never left the room or contacted anybody that it was a really bad case. It was an OB case, I'm OB. But you have to follow your chain of command, and I think a lot of times we don't remember that, but you have to notify somebody. And you have to notify, if it's an off shift, you would notify the house manager for support, and then the house manager might call the director or the manager at home, but I think that's something that really needs to be emphasized, is the chain of command is followed. And the hospital ended up getting cited for lost $12 million because we didn't follow the chain of command. The physician got a lot more. And it's very awkward sitting in court staring at your physician because they're looking right at you where they seat you, and you're answering questions about them, and it's not an easy thing to do. So please document your chain of command.
That comes up in a lot of depositions with nurses. Did you follow the chain of command? Did you go to the next level? Did you do this? That's not unusual.
What about our little cheat sheets, things that we carry around our brain, our clipboard? Should we be destroying those, excuse me, at the end of our shift, or should we hold on to them just in case we ever get called to court?
Well, they do ask for any personal notes that the nurses have made. If you have a journal at home and you go home and you write about the patients that you had that day, that is fair game. So anything that you write down about a patient, whether it's part of the official medical record or not, will be asked for.
So be careful.
All those little reports that you keep in your mailboxes, just because this patient seems to be a difficult patient, or the family seems to be a difficult family, they're going to sue one day. I'm going to keep my notes in my mailbox so it'll trigger my memory. That goes to court, and because we do all our notes in shorthand, they will rip your notes apart and make you look like an idiot.
Now, we all know there's difficult families and there's difficult patients. it's okay to put that nicely in the record. You know, we've had cases where the physician wrote, the patient is as big as a whale. The patient is, you know, all kinds of foul language. I mean, don't put that in the records. That is inappropriate, and your credibility and professionalism will be called into question. And the case will probably get settled but you can certainly put interactions that you've had with the patient or the family that have made you uncomfortable, or, you know, but document, if they say something to you in a foul language, put quotes around it. Because it's in the record, and then you're gonna have that recall. And when it's in the record and plaintiff's counsel is looking at that, and they're gonna say, ugh. I have a case that, you know, this family, nicest family, but they spent every day, every night at the hospital with their father. Very loving family, and they felt that the physicians were not paying enough attention to their questions and their needs. Fortunately, every physician, every nurse documented. I spent 45 minutes with the family discussing their questions about the condition, the treatment, the side effects. And so, you know, that paints this picture that, yes, you know, their father was sick, but they were getting around-the-clock attention from everybody at that hospital. So that really helps that, you know, in their note that spent 45 minutes with the family, spent 35 minutes with the family. And you know, the family was nice. They weren't mean, they weren't nasty, but that portrayed this picture of, here's a family that is very intensive, very needy, and everyone is spending a lot of time bending over backward to make sure that they are aware of what is going on, getting good consents, things of that nature.
So what, if a patient's family member is videotaping the patient's body, or maybe they said, my mother didn't come in here with any pressure ulcers, but now I see this big wound on her hip, and they're videotaping that, and they're not only taping the patient's body, but also videotaping the interactions between the patient and the nurses. Is that submissible in court?
If they're aware of it, I mean, do you have policies and procedures about videotaping? We get photographs all the time. I mean, I have cases where, here's this picture, and it's not dated, it's not, you know, this was present, you know, 3 days before the death, and it's like, well, how do we know that? Because there's absolutely no information on the picture that shows me the date, or who took it, or if this is even your mother. You know, I know a lot of hospitals now don't allow cameras in the delivery rooms, or we do get asked about cameras that are in surgery, or, you know, security monitors in the hospital. I mean, you know, you could document in the chart that they're doing it, but ideally you'd want to say, we don't allow, you know, if you got to pick language in every room saying we do not allow videotaping of patient care. And it's just so easy now with phones. I mean, it's, so, do you have any?
I was just curious, with speaking with Dana before, if there's a hospital-wide policy applicable to every unit, and I got the impression there is not. So that's just an internal question that the hospital has to decide. We can work with you guys on that and see what other hospitals are doing in that regard, because that is, I mean, if it's the patient videotaping themselves, they're, you know, I feel like they can probably do that. It's their own body. There's not HIPAA, but if somebody else is doing it, now HIPAA gets involved, and it gets very, very complicated very, very quickly in that regard. And who knows where that video is going to go? It's going to end up on YouTube. It's going to end up, you know, in the newspaper's hands. So the pictures, in my opinion, I'm better with pictures. I feel more comfortable with pictures, documenting the circumstance in that way, shape, or form. But videos, that makes me very uncomfortable. Any other questions? Nothing else? Nothing?
Nobody has any other questions? Nothing about anything?
Well, then let me wrap this up. We talked about how This Indiana state law requires that a patient's medical record contains the sufficient information to identify the patient so that each patient doesn't sound like the same thing over and over and over again in each and every chart. Support the diagnosis because each patient has different diagnoses, and justify the treatment and accurately document the course of the treatment and the results. Here's our hospital documentation policy, and please review it. I think during orientation, this is the first time that we bring it up because we emphasize it because of the documentation being necessary, extremely important, and our policy tells you how to do that documentation. We talked about different things that could hurt your documentation. Yes, I'm documenting, but you're copy and pasting, and we have 3 different nurses for 4 days in a row who documented the exact same thing. You'll be given a handout on your documentation do's and don'ts. We hope that this will be helpful. And if anybody has any questions whatsoever,
feel free to come up.
Yeah, you can come up afterwards. Well, thank you all for taking your time and coming.